Hey everyone, and welcome to probably the most ridiculous clear sign of the double standards that is in Dr. Beverly Cannone's courtroom. Dr. Beverage, Judge Beverage herself, because do you remember when we had Dr. Russell, one of the most impressive doctors who has ever testified in a case, had to sit through 2 days of voir dire, and then there was a filing by Bev saying, well, she has to stick within these parameters, and I nearly almost didn't allow her to testify. Mr. Jackson, there's no jury. If you all remember that, then let's look at this new filing that was made yesterday. Memorandum of decision and order in defendant's motion to exclude certain testimony of Robert Gilman and in the alternative request for a Daubert Lanigan hearing. There appears to be no dispute that the Commonwealth's proffered expert in meteorology, Robert Gilman, satisfies the foundational requirements set forth in Daubert v. Merrill Dow Pharmaceuticals and Commonwealth v. Lanigan, and therefore may testify as to the weather conditions on January 29th. That part, okay. However, the defendant seeks to preclude Gilman's from testifying as to the hardness of the ground resulting from the weather conditions. Yes, because he has no expert knowledge about that. He has no methodology. Remember Weaselface talking about methodology? He has no skills to prove how hard the ground was that day. And he has no data proving how hard the ground was that day. What does Beverly say? To the extent that the Commonwealth seeks to elicit such evidence that the defendant believes is beyond a witness' field of expertise, defense counsel can object to the line of questioning at trial if the proper foundation for such evidence is not established. See Commonwealth v. Genuine. Accordingly, the defendant's motion is denied. It's infuriating to watch how she treats two equal motions. When they wanted to preclude Marie Russell's testimony about how wounds appeared, she claims, well, she doesn't have the necessary expertise, so you can't even ask her. Now she's saying, well, Special Prosecutor Brennan can ask him, and then it's just up to the defense to yell objection, and then maybe I'll allow it if the foundation isn't met. Well, they will never ever be able to make the foundation because, one, he wasn't there. Two, he can take weather data and say, yeah, well, it was cold as that day. If it was, or, yeah, it wasn't that cold. But he has no way to prove beyond any reasonable doubt how hard the earth was. And they're going to pair this up with the neurosurgeon who says the impact on the ground is what caused his death. He has no way of telling that the earth is hard enough to make the neurosurgeon's testimony believable. This guy is only there not to talk about what if any snow. He's there to fake give an answer that the earth was so cold it was like falling on ice or a rock or whatever hardness level they're going to try and elicit out of him. But he has no effing knowledge that could in any way stand up to any testing because he did no testing. No one was out there with a thermometer, putting it in the ground and say, whoa, it's really cold. No one knows how cold the earth was that night, if it was frozen over. If I remember the weather charts that we have seen going around for that period, it hadn't been that cold leading into the night. And again, if she's going to allow a layman to speculate, hey, let me speculate as a layman. I live in a place where it gets cold. Not as cold as Canada or hell, which is known as Sweden in most places. But still, we do get a lot of frost. And the ground doesn't get hard from just 1 or 2 days of frost. It actually takes some time to make it as hard as she will hear in the courtroom. How can she claim that Dr. Russell, who is a trained police officer, who's a pathologist, who's a doctor, how can she claim she didn't have the established methodology or the necessary medical knowledge to have an opinion? But in this case, again, just like when her motion to dismiss all was leaning on, hey, trust me, bro, all you need to clear all of this up is just yell objection. Why isn't the defense and the state being treated in the same manner? It's infuriating, and everyone who has anything to do in the Massachusetts court system should fear going in front of Judge Bev, because she makes up the rulings after who she likes, not the law. This is clearly two-faced Beverage, showing that she don't care anything for justice. The only thing she cares for is little hanky-panky can get a win, Karen Reed can go to prison, and those fancy lawyers can go back to Boston or wherever they came from. This lady has nothing to do on the judge's stand. Sadly, you can't do anything about it. The only thing we can do is yell in videos and get absolutely infuriated that she has no fairness. I call her Beverage or Bias Bev, and she proves again and again that in her courtroom there's double standards. In her courtroom, as long as you're hanky-panky, you can effing lie. You can bring whatever witness you want. You don't have to prove anything. No case law, no affidavits, no nothing. How is this allowed when you have her precluding expert witnesses who actually have the necessary degrees from the defense? If she's going to do this for the state, let's make it a free-for-all. Let's make it fair. Let's bring in all the ARCA witnesses, not like last time where you chucked one out. Let's let Marie Russell talk about everything. But you won't do that. You will tie the defense and you'll let Brennan do whatever he wants. That's not fair. That's not justice.